May I please, Your Lordship? My Lord, I beg to mention item number 25. Here I've received instruction to, so kindly allow me 3 weeks time to file affidavit.
325.
Yes, my Lord.
The Government Counsel Tibago submits that he has received instructions and prays for
3 weeks
3
time.
weeks time to file his affidavit in opposition.
Lordship, there's an interim.
It's allowed. Learned counsel for the petitioner is present. The interim order passed earlier shall continue till the next date. Rest of the 3 weeks.
Much obliged.
May it please, Your Lordship.
Yes.
Lordship, I beg to mention item number 5 to 8, Your Lordship. We have been engaged here in newly counsel, Lordship. 5 to 8, Your Lordship.
8. For respondent.
For the in item number 5, I'm for the respondent. In other 6 to 8, I'm for the petitioner, Your Lordship.
Okay. In 5,
Rasdeep,
respondent
I'm for
number,
the respondent. 1, Your Lordship.
respondent 1.
1, Your Lordship.
Item number 5 for respondent 1.
Yes, Your Lordship. Item number 5, respondent number 1.
Item
6 to 8, Lordship. I'm for
to 8 petitioner.
6 to 8, I'm for the petitioner, Your Lordship.
Okay. Your name?
As Gautam, Your Lordship.
S. Gautam. Learned counsel, Shri S.
Gautam. Gautam.
submits that he has received instructions to appear on behalf
Newly.
of newly engaged. He has been newly engaged to
Right.
appear on behalf of respondent number 1 in criminal petition 52 of
Item number 5.
4 and for the petitioner in criminal petition 18 of 23 and 37 of 23. And accordingly prays for some time to you're yet to file your power.
Lordship, we have filed our power. But, there's some discrepancies in the filing. That is why, Lordship, we 2 weeks time, Your Lordship.
And he is accordingly prayed for 2 weeks time to file his Vakalatnama and to bid further instructions. So praise the Lord. Learned Counsel Esther appears for. You are for?
Petitioner, Your Lordship.
For the petitioner in 5.
5.
For the petitioner in criminal petition 52 of 24, and there's no objections. Accordingly, list the matter after, you said 2 weeks. 2 or 3 weeks.
2 weeks, Your Lordship.
List the matter.
2 weeks, Your Lordship.
Okay.
Oblige, Your Lordship.
Can you just increase the volume a bit? I think they can't hear properly. Volume.
May please, Your Lordship. I beg to mention item number 15 and 16, Your Lordship.
15 and 16. Yes.
If this matter were listed on 23rd of June, Your Lordship. 15 and
On the
16.
prayer of the learned counsel for the petitioner, list the matter on 23rd June. For
23rd June.
23rd June.
Oh, Lordship.
Lordship, we have difficulty on 23rd. Can you list the matter after the break, summer break?
After summer break.
Yes.
List after the summer break.
Much obliged.
Maybe Lordship. Lordship, I beg to mention item 2. Lordship, this is a consensus pair. Lordship, if the matter can come up on 23rd of June, Lordship, it's a fixed item,
23rd.
23rd. Second,
Counsel for the
item 2,
petition.
I'm for the petitioner.
For listing the matter on 23rd June. The prayer is not objected by the learning council for the respondents. List the matter on 23rd June.
Lordship, as an interim, kindly let him
The
continue.
interim order passed earlier shall continue till the next date.
Lordship, I also beg to mention item number 4. Lordship, here I'm yet to file my reply. I've received the reply, but there were some mistakes, so I have to send back to Kolkata, the petitions from Kolkata. So, Lordship, may kindly grant me three more weeks' time, Lordship.
Counsel for the petitioner, she for the place for 3 weeks' time to file a reply to the
That will be filed by the
respondents.
Lordship.
Prayers along, list the matter after 3 weeks.
Lordship, as an interim, kindly
The
let him continue.
interim passed earlier shall continue till the next date.
Will you oblige, ma'am?
Please, Your Lordship.
Yes.
I beg to mention item 19 from the hearing list, Your Lordship. Your Lordship, this is a joint prayer. This matter may kindly be listed after the summer break, Your Lordship. Item 19.
On the prayer of the parties, list the matter after the summer break for hearing.
Oblige, Your Lordship.
May I please, Lordship. My lord, in hearing item 21,
Hmm.
I am for the respondent number 1.
Hmm.
So here I have another item today.
Yes,
So may I pray that this item 21 and 22 be listed on 16th,
21 and
22.
22.
Yes.
Hmm.
I
Lord, in item 21,
Hmm.
I am the petitioner. And there is urgency in this case. I would not object with a condition that the petitioners should not be subjected to unnecessary harassment because this is a case
Hmm.
in a village, which is a dispute between the village council and one KEL and the petitioner's clan.
Hmm.
Now, since the petitioner's clan is in the minority group, the villagers are giving unnecessary harassment in so many ways, which is very difficult to express also, because nowadays, all the schemes, everything is village-based. Lordship is well aware, so many schemes, facilities, even collection of materials, all these things. So I would not object if the petitioner's clan is not subjected to any form of harassment. Earlier, we were also denied of issuing the certificate for ST, SC, ST certificate also,
Hmm.
but that has been relaxed. That has been given, but there are so many restrictions for the petitioner's clan. So I would not object if the petitioner's clan is not subjected to any unnecessary harassment.
I represent one KEL,
Hmm.
chairman represented by another.
Oh,
Village
yes, yes, yes.
council, their KEL, they are one group. And the petitioner's clan is another.
Who is representing the chairman?
Lordship. Definitely that part as.
Urgency is
chair-
involved in
as
this
chair- chairman,
case, Lordship.
16, we can take it up, no problem.
16th.
Yes.
As a fixed item.
Yeah, as a
Lordship.
fixed, either
That
one,
is Monday.
no problem.
On the prayer made by the learned counsel for the respondent number
One.
one, list the matter on 16th June as a fixed item for hearing. So,
Since there is urgency in the
uh,
case.
counsel, Mr.
16th
Learned Senior
item.
Counsel, Mr. Siti Jamir,
Okay.
appearing on behalf
We'll
of the
take up
petitioner,
no problem.
has submitted that the adjournment may be granted on the condition that the petitioners and that the petitioner's clan, that
Yes,
the petitioner's clan may not be disturbed or harassed by the village authorities.
Yes, that-
Till the next date fix, comma, it is directed that the village authorities will make sure that
okay, okay.
no harassment is meted out to the petitioners. So, please don't 16th.
and there is an interim that may be continued.
The interim order passed earlier shall continue till the next date. And item 22,
My lord, 22, in that case, on that day, I have three together, then let it
Let
be
it be
after,
another
yeah,
day.
let it be another date, after 3 weeks, my lord.
22 lists the matter after 3 weeks
Yes.
on the prayer of the learned counsel for the petition.
Major. Interim is there, my lord.
Interim order passed earlier shall continue till the next date.
Major.
May I please, your ladyship? I beg to mention item 20.
22-0,
Yes, your lordship.
yes.
If the matter may come up after 2 weeks on the consensus prayer.
Learned counsel for the petitioner, for the appellant, has mentioned for listing the matter after 3 weeks, and the consent of the opposite part and consent of the learned counsel for the respondent has also been obtained. So accordingly, list the matter after 3 weeks for hearing. Yes.
Yeah, please, your lordship,
Yeah.
I beg to mention item 12 on behalf of Wati Jamil. Since my senior is disposed today, kindly
Item
12.
12.
Kindly fix this matter on Thursday.
Yes, other side. Wati Jamir is for respondent.
6, 11, 16, 19, and 32.
Is 11, 19, and 32.
16.
No,
and 32.
16, 19, and 32. Any objection?
Lordship, yes, then I may be heard, Lordship,
My,
in
my-
that case.
my lord, on Thursday, I'm going to pack one criminal case.
Hmm.
So I have declared them, check that is.
Okay, this is that matter where adjournment was sought last week also.
Yes, Lordship.
Thursday, it's only day after, one day. If council is not feeling well,
Good
then,
attitude.
Can it be taken up on the 17th?
Tuesday,
Just 1 minute, huh? 17, that's me. Okay,
17?
no problem.
mention has been made, item 12, say mention has been made on behalf of Sriwati Jamir, learned counsel appearing for respondent number 6, 11, 16, 19, and 32. That the praying for listing the matter on 17th June as the council is indisposed. So accordingly, no, learned counsels for the petitioner and anyone else for the respondents.
Yes, Lordship, I'm also for the respondent number.
Council such and such, just get your names. Present for the respondents and the petitioner. Accordingly, this is the matter on 17th June.
Major.
Oblige.
My lord, there is an interim.
Interim order passed earlier shall continue till the
Till 17. Major.
till the next date.
May I please, your lordship?
Yes.
May I be pleased to mention item 11, your lordship. Your lordship, I'm yet to receive the record, your lordship, case record. So your lordship, let it come after vacation since the record has to come from Mukokchung.
Learned PP. Ms. Levika has prayed for listing the matter after the summer break as she's yet to receive the case records from the from which court?
From the lower, from the district
From the
court.
trial court in Bokchung. Stop. Learned counsel for the petitioner is present. list the matter after the summer vacations.
Much obliged.
Privilege, Your Lordship. Lordship, I beg to mention hearing item number 14. Lordship, my senior is out of station for his personal work, so I pray that let the matter may be listed after vacation.
14. Mention is made by Mr. Such and such, praying on behalf of his senior, Mr. Santiago, who is
Yeah.
indisposed
Yes,
or
Lordship.
out of station.
Out of station,
Is
Lordship.
out of station. So accordingly, list the matter after the summer vacations. Learned government advocate is present.
For pleasure.
Yes.
Yes, Your Lordship. I beg to mention hearing item 23 on behalf of Upendra Pandey. The leading counsel has some personal difficulties today, so kindly this matter may be fixed on 27th of July.
7th. Learned counsel, Ms. Such and such has mentioned, has made a prayer on behalf of Mr. Upendra Pandey, who has some difficulties today, and has prayed for listing the matter on 27th June. Accordingly, prayers allowed, list on 27th June.
My pleasure, my lord. Lordship, I beg to mention here in item number 9 and 10. Lordship, I'm informed by the
9 and 10,
Lordship.
yes.
Lordship, I'm informed by the leading counsel that he may be allowed to complete DGP Assam, IGP administrative, SP Kolkata, and as well as the officer in charge of police, Chungajan police station as a party respondent in this case.
You file an IA for that? Learned counsel, Manchong
Manchong
Konyak,
Konyak,
has prayed for
2 weeks time. Lordship.
2 weeks time to file an IA for implement of
DGP Assam,
DGP Assam,
IGP administrative,
IGP administration,
SP Kolkata,
SP Kolakat,
officer in charge of the Chungajan police station.
OC of
Chungajan police
Chungajan
station.
Police Station. Stop. Prayers allowed, list the matter after 2 weeks. And Learned BP.
May I please, Your Lordship, let them file honor before that, Your Lordship, because it will be more or less delay in dictates, Your Lordship. Because they will implement this one, notice will go, and I mean, like the
Yes,
interim will
within-
keep on
Yes, Lordship.
extending.
Yes,
Will
within,
be filing.
the Learned Council is directed to file the IA within, before the next date.
And let the copy also be furnished to me so that on the next day,
No,
I
immediately
mean,
after
at
you
least.
file your supply.
Yes, Your Lordship.
Lordship, the interim order mechanism. will not be
The interim order pass will continue till the next date. Now, the PP is present and Ms. Livika is present for the state of Nagaland. Yes.
obliged.
For motion, item number 1.
May I please, the Lordship? This instant contempt petition is being filed for non-compliance of this honorable court's judgment and order dated 27/2/2025, passed in WPC 37 of 2023, whereby this honorable court had directed the state respondents to consider the case of the petitioner for appointment to any grade 3 post in terms of the settlement dated 7/12.
Where is the direction?
The direction is an extra A, page 20. Operative portion is paragraph 24.
Para 24.
Yes, Lordship.
I think this respondent number 1 is already retired. You may have to implement the new respondent. You find out.
Okay.
The present contempt petition under section 11 and 12 of the Contempt of Courts Act 1971, read with Contempt of Courts Gauhati High Court Rules 1977, has been filed by the petitioner alleging willful and deliberate disobedience of the order of this court dated 27/7/2025, passed in WPC 37 of 2023. So by the order dated 27/2/2025, the respondent authorities have been directed to consider the case of the petitioner for appointment to any grade 3 post in terms of the settlement dated 7/12/2016 within a period of 2 months from the date of receipt of a certified copy of the order. So the order was passed on 27/2/2025, and it is stated that the authorities are yet to take any steps in compliance of the said order of 27/7/2025. So I've heard learned counsel for the petitioner, Miss Such and Such, stop. Issue notice to the respondents 1 and 2, returnable within 4 weeks. Stop. The petitioner shall take steps for notice on the respondents by registered post with AD as well as usual process within a period of 3 working days from today. This after 4 weeks.
For motion from the supplementary cost list, item number 24.
Please, Your Lordship. Your Lordship, here the present contempt petition is for non-compliance of this honorable court order dated 17th February 2025, which was passed in WPC number 153 of 2025.
Yes, what was the direction?
Your Lordship, here this honorable court has directed the state respondents to examine the case of the petitioner and to grant minimum scale of pay within 60 days or Your Lordship, the honorable court order is in page number 10, annexure 1. And the relevant portion is in page number 16, para 15. Your Lordship, in para 15, 4th line. The petitioner number 2, 3, and 4 shall, however, minutely examine the case of the petitioners and take a decision as to whether the petitioners are discharging the same nature of works, duties, and responsibilities and discharged by the regular 4 employees and or by those in the same corresponding post for granting the minimum scale of pay to the petitioners within a period of 60 days from the date of passing of the order. Any decision taken by the state respondents shall be reasoned decision and after proper application of mind shall be therefore communicated to the petitioners. Your Lordship, and accordingly,
Within 60 days.
yes, my Lord.
The present application under section 11 and 12 of the Contempt of Courts Act 1971, read with Contempt of Courts Gauhati High Court Rules 1977 has been filed by the petitioner alleging willful disobedience of this court's order dated 17/2/2025, passed in WPC 153 of 2023. Stop. By the order dated 17/2/2025, the respondent number 2, 3, and 4 were directed to examine the case of the petitioners and to take a decision as to whether the petitioners are discharging the same nature of works, duties, and responsibilities as discharged by regular grade 4 employees and by those in the same corresponding post for granting the minimum scale of pay to the petitioners within a period of 60 days from the date of the order. Stop. It was also directed that any decision taken by the state respondents shall be a reasoned decision and shall be communicated to the petitioners forthwith. Stop. I refer to counsel for the petitioner, Ms. Such and Such. It is stated that even after the expiry of 60 days, the respondents are yet to take any decision in the said matter and no decision has been communicated to the petitioners as directed. Stop. Issue notice to the respondents number 1, 2, 3, 4, 5, 6, and 7.
My lord,
Yes.
in this contempt petition is 1 to 3
Where is it?
in page number 5. The respondents are
Okay, okay. The respondents number 1, 2, and 3, returnable within 4 weeks. So the petitioner shall take steps for the notice by registered post with AD, as well as usual process within a period of 3 working days from today.
Objection.
Reports.
For admission, I beg your pardon, for orders, item number 13.
May I please, Lordship? My lord, I have instruction to appear on behalf of respondent number 1, my lord.
Hmm.
So can you allow me 3 weeks time, my lord?
Counsel, for the petitioner, Mr. N. Longcomer is present.
For the
Oh, you're also for respondent?
Yes.
Okay.
We are applying for the respondent.
Learned counsel. Petitioner, okay. Learned counsel for the petitioner, Ms. Such and Such is present. Learned counsel, Mr. N. Longcomer is present for respondent number 2. So, learned counsel Tipa Pom submits that he has been, he has his instructions to appear on behalf of respondent number 1. And accordingly prays for
3 weeks time.
3 weeks time to file his, now you have to file your Vakalat Nama also.
Yes, my lord.
To file his Vakalat Nama and affidavit in opposition, if any. Stop. List the matter of the changes.
Much obliged.
For hearing, item number 17.
I think there is one admission matter now. I think there is one admission matter. Supply.
From the supplementary cost list. For admission, item number 26.
May I please, your lordship? My lord, I am appearing through VC. Am I audible, my lord?
Yes, yes.
Yes, my lord, that is the same matter appointment of arbitrator, my lord. My lords have yesterday proposed one name of Justice Sharma.
Lady, if direction will be given to the registry to furnish the list of the panel so that to the state, so that we'll be able to examine the panelist and give us 1 day, and the matter will be listed again, so that we can come back with. Yesterday I was given the instruction whether the name just suggested Justice.
I think it is there in the list.
Yes, but want to examine other names also in the panel. So if 1 day may be given by the matter, if my lady can accommodate, matter may be listed again day after tomorrow, but give us 1 day break so that we can.
My lord, that will be same, my lord. All the honorable retired judges.
All
are
that long
same.
way I've been trying to be constructive, we are trying to make it simple. It is the arbitrator, the petitioners just make it things complicated. Otherwise, by now arbitration process will be on.
No, you have made the things
Since 2007
I
to
have-
14, we have been to.
Yes, kindly see my,
Haryana, Punjab courts, ways
Yes.
in the state paid unnecessary.
Therefore, we are here.
Complications.
Kindly see the annexure P19, 12th of
It-
August 2024. You have not replied to that.
However,
I'm sorry.
it really wants, I think if they really want to go very technical, I think we may even need to file affidavit in the opposition. Today.
But you are admitting that.
Asking for that 1 day. so that-
We are not going to the merit now.
Yes.
But we're just on the point of appointing an arbitrator.
Yes.
So, okay, tomorrow,
No, tomorrow, my leadership, tomorrow, so department has, the government has to examine, so at least 1 day gap we need.
Thursday,
Yes, that's fine.
Thursday.
My lord, this is,
Direction will be given to
my
furnish.
lord may say no further adjournment will be given.
Yes, we'll see that, yes. Because, see, government authorities, the working system is a bit different. It has to go through various channels. So that is a difficulty which they are facing.
And my lord, I'll humbly submit, my lord, all the honorable retired judges are same and
No, but I think
point
there is
is-
a panel of arbitrators, which the.
Honorable
Gauhati High
Justice,
Court-
Honorable Justice Sharma is, I guess, is in the panel.
Yes, I'm sure he's in the panel because he has
Yes.
also taking up arbitration matters.
So I have no objection
Mm.
with any of the honorable retired judge. But I don't know why my learned friend wants a specific, anyway, my lord. But my lord may kindly mention there should be no further adjournment on this issue.
He's mentioning on the basis of instructions, so.
Yes, ma'am.
The for the parties are present, so. The registry is directed to place the list of arbitrators in the Gauhati High Court before this court, and thereafter list the matter on Thursday. Date, give a date.
My lady, if a
And-
copy may be furnished to us today so that we can go through it tomorrow with the. That is possible.
Okay, and also supply a copy of
Yes.
the list of arbitrators to the learned counsels for the parties. This on Thursday.
Yes, my lord. My one of the associate is present in the court, my lord. He can have the copy.
This list matter on Thursday.
I'm so grateful. My lord may kindly say no further adjournment will be granted. My lord may kindly mention it.
Made clear that no further adjournment will be.
I'm so
granted.
grateful. I'm so grateful. I'm so grateful.
For admission, item number 3.
Mr. Lordship,
Yes.
here the respondent was directed to regularize the service of the petitioner.
Mm,
And accordingly, in compliance with the court's order, we had regularized his service.
Okay,
Yes. So I pray the matter may be closed.
let's see the prayer. Direction.
That's in page 13. Para 9. Page 30, para 9. In view of that has been stated above, the repetition is hereby disposed of with a direction that the respondent should regularize the petitioner service within a period of 4 months from the date of receipt of a copy of this order so that he will at least enjoy pension and pensionary benefit. Yes.
Lordship,
Yes. We'll
Lordship,
close it.
no, your lordship, we are yet to connect it with the petitioner. Therefore, meanwhile, we will seek instruction from the client also.
No, it's a
No.
contempt, it's a between the court and
Yes,
the
It's
contemptor.
between the court and the contemptor. Actually, now petitioner has nothing to do with
Mm.
this, nothing to do with this. And the direction is here and the complaints is here, so nothing more. At the outset, the MS V Shukri, learned counsel appearing for
Respondent number 2 to 3.
respondent number 2 to 3 and Nagabi for respondent number 1, have produced a copy of the order number CE/PHE/EST/CC/2016 dated 13th May 2025, by which the petitioner Shri Angpe Kongyak ANGPHEI Kongyak Word Charge Kalasi, retired with effect from 13/9/2019, has been regularized as policy against an ex post facto regularization post created with effect from the afternoon of 13/9/2019 in the scale of pay level -1. Stop. It is stated that the service regularization of Shri Angpe Kongyak is purely for the purpose of granting pension benefits only. Stop. In view of this, in view of the order dated 13 May 2025, the direction of this court passed in WPC 21 of 2021 by order dated 11/4/2022 has been complied. Stop. Accordingly, nothing remains to be adjudicated in the present petition, and the petition is disposed of.
Much obliged.
For hearing, item number 17.
This is the compassionate
Yes.
appointment matter.
Yes,
It's- you've
your
clarified.
yes, your lordship, the petitioner wife was an employee of railway. Your lordship, any matter related to the service, the Kate is the exclusive jurisdiction, your lordship. And this objection I have also raised in my affidavit, that after exhausting all the remedies available in the department, the petitioner have to approach the Kate. And the High Court is only the appellate jurisdiction, your lordship. I have raised the objection in my reply at paragraph 11. May I, lordship, that is regard to the statement made in paragraph number 16 and 17 of the writ petition, the answering deponent respectfully state that even otherwise pertaining to no efficacious alternative remedy open to the petitioner, the answering deponent respectfully state that the petitioner failed to approach the Central Administrative Tribunal before approaching this honorable court section. According to section 14(1)(c) and 3 of the Administrative Tribunal Act 1985, wherein 14(1)(c) state that all service matter pertaining to service in connection with the affairs of the union concerning a person appointed to any service or post referred to in subclause 2 or subclause 3 of the clause B, being a person whose service have been placed by a state government or any local or other authority or any corporation or society or other body at the disposal of the central government for such appointment. Your lordship, in the instant case, the petitioner wife was an employee of railway government. Your lordship, any remedies, if they are aggrieved, the exclusive jurisdiction lies with the Kate.
Service matters.
Service matter. Yes, your lordship, they are demanding appointment on the compensatory ground. Your lordship, I would like to refer section 28 and 29 of the Administrative Tribunal Act 1985.
Is it annexed?
No, it is not annexed, your lordship. But I have a copy. Section 28, your lordship, page number 15. Exclusion of jurisdiction of court except the Supreme Court under Article 136 of the Constitution. On and from the date from which any jurisdiction, powers and authority becomes exercisable under this act by a tribunal in relation to recruitment and matter concerning recruitment to any service or post or service matter concerning members of any service or persons appointed to any service or post, no court except Supreme Court or number B, any industrial tribunal, labor court or other authority constituted under the Industrial Dispute Act 1947 or any other corresponding law for the time being in force shall have or be entitled to exercise any jurisdiction, powers or authority in relation to such recruitment or matters concerning such recruitment or such service matters. Your lordship, the petitioners cannot directly approach this honorable High Court. Your lordship, only they can approach the Supreme Court if it is needed.
But can compassionate appointment be termed as service matter?
Yes, your lordship.
It is related to the appointment, your lordship, the service.
Normally, compassionate appointment is not a mode of recruitment, actually. As per the rules, it is not a mode of
Yes.
recruitment.
Your lordship, the
It is-
compassionate appointment as against the service of the deceased. That is also related to the service, your lordship. Your lordship, I would like to refer one Supreme Court, the constitutional bench, the 7 judges benches in Chandra's cases, where I will read out the operative part, your lordship. The last part, the paragraph 100. Paragraph 100. In view of the reasoning adopted by us, we hold it clause 2D of Article 323A and clause 3D of Article 323B. To the extent they exclude the jurisdiction of the High Court and the Supreme Court under Article 226, 27 and 32 of the Constitution are unconstitutional. Section 28 of the Act and the exclusion of jurisdiction clauses in all other legislation enacted under the aegis of Articles 323A and 323B would to the same extent be unconstitutional. The jurisdiction conferred upon the High Court under Article 226, 27 and upon the Supreme Court under Article 32 of the Constitution is part of the inviolable basic structure of our Constitution. While this jurisdiction cannot be ousted, other courts and tribunals may perform a supplemental role in discharging the power conferred by Article 226 and 27 and 32 of the Constitution. The tribunals created under Article 323A and Article 323B of the Constitution are possessed of the competence to test the constitutional validity of statutory provision and rules. All decision of this tribunal will, however, be subject to scrutiny before a divisional bench of the High Court within whose jurisdiction the concerned tribunal falls. The tribunals will nevertheless continue to act like court of first instance in respect of the areas of law for which they have been constituted. It will not therefore be open for litigants to directly approach the High Court, even in cases where they question the virus of statutory legislation, except where the legislation which creates the particular tribunal is challenged. By overlooking the jurisdiction of the concerned tribunal, Section 5(6) of the Act is valid and constitutional and is to be interpreted in the manner we have indicated. My lord, the law is very clear that if the litigants have any grievances, they have to approach the tribunal before approaching the High Court, your lordship. This decision is given by the 7 benches judges in L. Chandra Kumar. This is the leading case as related to the.
No, but what were the facts here?
Your lordship.
Was it compassionate appointment?
Your lordship, compassionate appointment, your lordship. Other service benefit they have already availed, your lordship.
No, the Supreme Court judgment, the facts of this judgment.
It is related to the service. Any services.
Not compassionate.
Not compassionate exactly, your lordship, but any services, any matter related to service must be adjudicated before the tribunal, your lordship.
Then what else?
So my prayer, your lordship, may kindly endorse this case to the tribunal for adjudication of the disputes, your lordship.
But when the petitioner is eligible, why are you reluctant?
Your lordship, he is not eligible. He's not, there is a dispute, your lordship. They have never approached the railway authority for any compassionate appointment. And when they have approached, it is more than 5 years, your lordship.
No, the records show that this was before 5 years.
So, your lordship, that is the letter given by us. Your lordship, very interestingly, the wife of the petitioner, he was also appointed on compassionate ground, since his previous husband was died in harshness. Your lordship, thereafter, she was availing compassionate appointment as well as the family pension. Your lordship, the family pension, it says that when she remarried, she have to intimate the department so that the family pension will be stopped. Your lordship, till she died, she was withdrawing the pension without informing the department. So that is why, your lordship, when they moved an application for other service benefit, the department has written a letter that even the department was not aware that you are the husband of the deceased, because neither you have informed the bank nor the authority, your lordship. In their reply, your lordship, they have affidavit in reply of my reply.
Affidavit in reply.
Given by the petitioner.
On behalf of the petitioner.
Yes, your lordship. Your lordship, annexure 1, page number 9. This is the letter they have written to us. Prayer for payment of GPF, subject, your lordship. Prayer for payment of GPF, gratuity, family benefit, group insurance scheme, and all such other services benefit as may be admissible in respect of the deceased late Srimati Kiria Basford. Sir, most humbly and respectfully, I beg to submit as follows for your kind perusal and sympathetic condition thereof, that my wife, late Srimati Kiria Basford, was employed under NF Railway as F/SFLA 2 and ML Dimapur, and she died in harshness in Central Railway Hospital, Maligaon on 23/5/2004 due to railway accident at LC Gate, Maligaon, ST/I over S/line in between Kamakhya and Gauhati railway station, leaving behind the legitimate baby girl named Kumari Lakshmi, who was born on 1/5/98 out of her wedlock with me. That the GPF, gratuity, family benefit, group insurance scheme, and other service benefit as may be payable by the NF Railway in respect of the service of my deceased wife has not been till today. Be it respectfully further stated, I have no permanent source of income but maintaining the baby girl and myself out of merger wages and living in hardship with the baby due to non-receipt of the aforesaid service benefit payable by the NF Railway in respect of my deceased wife. Therefore, with great expectation and hope, I pray that you will be gracious enough to release all the service benefit of my deceased wife, late Srimati Kiria Basford, to me and my baby girl at the earliest, for which your act of kindness I shall be ever grateful to you. Your lordship, we have replied to this letter in the next page. Your lordship, I will read the type copy. It is on page number 11. Subject, late Kiria Basford ex SFLA/DMF. In response to your application dated 28/4/2006, the letter which I read just now, this is to inform you that late Kiria Basford ex SFLA/DMF was appointed in railway on compassionate ground consequent to the death of her husband, late Siba Basford, and was drawing her family pension regularly from bank without submitting any remarriage certificate as certified by pension disbursing bank. Further, she has not submitted any family declaration nor availed of privileges, pass, and medical facilities. Moreover, she expired on 23/5/2004 after 2 years through your application dated 28/4/2006, annexing marriage declaration treatment paper claiming to be the husband for FS dues and CGA, which cannot be accepted in office if any declaration submitted by the ex-employee. Hence, your claim for FS dues and CGA cannot be considered for want of proof your genuineness as husband.
But later this was given, isn't it?
Yes, later on, your lordship, they have submitted the succession certificate. So all the benefits we have given to her.
Lordship,
Yes.
may I humbly submit?
Yes.
This argument of learned friend that as regards to this, I have not submitted any application as such. Your Lordship, the pension payment which was ordered in my favor in 2010. So this argument goes off that whether I was eligible or not. Two things to be decided. One was the final settlement, one was the compassionate ground appointment. That final settlement was decided in my favor as per that letter also given by them. Now, Your Lordship, the important aspect is that the circular which learned friend has mentioned on the other day at page 11, it says in the first para itself, it says that at present, the orders linking to appointment on compassionate grounds are scattered in a number of office circulars / orders. Now, Your Lordship, may I humbly take Your Lordship to their affidavit in opposition at page 14. Lordship, the
time limit.
Time limit. Lordship, that relevant page is there in page 15, the circular dated. Page 15 at the top, Lordship. That circular dated, it dates back to 1985. And therefore, Lordship, the most.
Page 15.
Page 15, the first para, the first line itself, the
Where
above.
that occurred, this one?
The above delegation of powers is.
Okay, is current up to 31/3.
Yes, but that circular date is 1985, 18/4/1985. And there is one more circular of 1990.
One is 18/4/95, one is
18/4/1990. Your Lordship, the most recent of edition is 2024 edition. And may humbly take Your Lordship to the time limit for making compassionate appointments. It's at page 99. It's at page 99. And at the last para, Your Lordship, page 99, may humbly read this time limit for making compassionate appointments. All requests for CGA submitted within the prescribed period of 5 years from the date of death, medical invalidation 2 years of attaining majority for ward registered earlier as minor, shall be finalized, decided by the DRMs, CWMS, so-and-so competent authority. Such cases not received within the period of 5 years will be considered as per the following schedule by the authority indicated against it. Your Lordship, in the last page, at page 100 is very crystal clear, Your Lordship. Beyond 5 years and up to 20 years, it's the DRMs. And my entire notifications, representation, whatever I have sent to the DRMs, it's 5-6 representation of mine. And it was sent to the DRMs. And it is very clear out here that beyond 5 years, even if for a moment, if I presume that I have not given in 2006, now this argument goes off. This is the latest amendment.
This is notification of,
It's 2023, that below that. 2023,
okay, 1/2/2023.
yes, your lordship. And all my representations are within that period.
You just supply a photocopy of this.
Yes, your lordship.
Yes.
And therefore, your lordship, furthermore, that my affidavit in reply, dear learned friend has already read out for your lordship. And there they clearly say that since my genuineness, my genuinity as regards to the husband was challenged, I produced the succession. I produced all necessary documents what the respondent required, and thereafter only that pension claim was considered in my favor. And therefore, one subject matter was decided in my favor and the other was not addressed. And that was well within the limitation period. And as per the latest circular, it's 20 years. It's beyond 25 years, but that is up to the GM level, your lordship. I'm not going to that. My address was come all to the DRMs. And that says that it's 5 to 20 years, your lordship.
And what is the procedure in the railways? Like, because in the state government, usually they maintain a list in chronological order
Yes,
for
your lordship.
compassionate appointment, and according to the dates they appoint. So what is the procedure in the railways? Do they have any procedure, any scheme?
Your lordship, the appointment in compassionate ground is not a matter of right. Your lordship, we have to see the immediate relief, whether they are in a financial crisis or not, your lordship. Your lordship, to clear this, I would like to refer one Supreme Court apex bodies, one leading cases in Umesh Kumar Nagpal versus State of Haryana. Your lordship, the first paragraph, the judgment of the court was delivered. These two petitions are directed against the decision dated 18/12/92 of the division bench of the Punjab and Haryana High Courts in letters. Present appeal number. So.
Where are you reading from? Para?
Your lordship, para 2 now.
Para 2.
2 in the second page. The questions related to the consideration which should guide while giving appointment in public services on compassionate ground. It appears that there has been a good deal of obfuscation on the issue. As a rule, appointment in the public service should be made strictly on the basis of open invitation of application and merit. No other mode of appointment nor any other consideration is neither the government nor the public authorities are at liberty to follow any other procedure or relax the qualification laid down by the rules for the post. However, to this general rule, which is to be followed strictly in every case, there are some exceptions carved out in the interest of justice and to meet certain contingencies. One such exception is in favor of the dependents of an employee dying in harness and leaving his family in penury and without any means of livelihood. In such cases, out of pure humanitarian consideration, taking into consideration the fact that unless some source of livelihood is provided, the family would not be able to make both ends meet. A provision is made in the rules to provide gainful employment to one of the dependents of the deceased who may be eligible for such employment. The whole object of granting compassionate employment is thus to enable the family to tide over the sudden crisis. The object is not to give a member of such family a post, which much less a post for post held by the deceased. What is further, mere death of an employee in harness does not entitle his family to such source of livelihood. The government or the public authority concerned has to examine the financial condition of the family of the deceased, and it is only if it is satisfied that but for the provision of employment, the family will not be able to meet the crisis that a job is to be offered to be eligible member of the family. The post in class 3 and 4 are the lowest post in non-manual and manual categories. Hence, they alone can be afforded on compassionate ground. The object being to relieve the family of the financial destitution and to help it get over the emergency. The provision of employment in such lowest post by making an exception to the rule is justifiable and valid since it is not discriminatory. The favorable treatment given to such dependent of the deceased employee in such post has a rational nexus with the object sought to be achieved, with relief against this situation. No other posts are expected or required to be given by the public authorities for the purpose. It must be remembered in this connection that as against the destitute family of the deceased, there are millions of other families which are equally, if not more, destitute. The exception to the rule made in favor of the family of the deceased employee is in consideration of the service rendered by him and the legitimate expectation and the change in the status and affairs of the family and engendered by the erstwhile employment which are suddenly upturned. Paragraph 3, Your Lordship. Unmindful of this legal position, some government and public authority have been offering compassionate employment sometimes as a matter of course of irrespective of the financial condition of the family of the deceased, and sometimes even in post above class 3 and 4 that is legally impermissible. Paragraph 4, it is for this reason that we have not been in a position to appreciate judgment of some of the High Court which have justified and even directed compassionate employment either as a matter of course or in post above class 3 and 4. We are also dismayed to find that the decision of this court in Sushma Gosai versus Union of India has been misinterpreted to the point of distortion. The decision does not justify compassionate employment either as a matter of course or in employment in post above class 3 and 4. In the present case, the High Court has rightly pointed out that the state government instruction in question did not justify compassionate employment in class 2 post. However, it appeared from the judgment that the state government had made at least one exception and provided compassionate employment in class 2 post on the specious ground that the person concerned had technical qualification such as MBBS, BE, BTech, etc. Such exception as pointed out above as is illegal since it is contrary to the object of making exception to the general rule. The only ground which can be justified compassionate employment is the penurious condition of the deceased family. Neither the qualifications of his dependent nor the post which he held is relevant. It is for the reason that we are unable to understand the following observation of the High Court in the impugned judgment. We are of the view that extraordinary situations require extraordinary remedies, and it is open to the government in real hard cases to divide from the letter and spirit of the instruction and to provide relief in cases where it is so warranted, to hold as a matter of law that the government cannot divide even minutely from the policy of providing appointment only against class 3 and 4 posts would be to ignore the reality of life these days. It would be ridiculous to expect that a dependent of a deceased class 1 officer should be offered appointment against a class 3 or 4 post, while we leave it to the government to exercise its discretion judicially in making appointment to class 1 or 2 post on compassionate ground. Yet a word of caution needs to be struck. It is to be noted that such appointments should be ordered in the rarest of the rare cases and very exceptional circumstances. As a matter of fact, we would recommend that the government should frame a policy even for such appointment. Paragraph 5. It is obvious from the above observation that the High Court endorses the policy of the state government to make compassionate appointment in post equivalent to the post held by the deceased employees and above class 3 and 4. It is unnecessary to reiterate that these observations are contrary to law. If the dependent of the deceased employee finds it below his dignity to accept the post offered, he is free not to do so. The post is not offered to cater to his status, but to see the family through the economic calamity. For this very reason, the compassionate employment cannot be granted after a lapse of reasonable period, which must be specified in the rules. The consideration for such employment is not a vested right, which can be exercised at any time in future. The object being to enable the family to get over the financial crisis which it faces at the time of the death of the sole breadwinner. The compassionate employment cannot be claimed and offered whatever the lapse of time and after the crisis is over. Paragraph 7. It is needless to emphasize that the provision for compassionate employment have necessarily to be made by the rules or by the executive instruction issued by the government or the public authority concerned. The employment cannot be offered by an individual functionary on an ad hoc basis. Your Lordship, the law is very clear. Compassionate appointment is basically for meeting the financial crisis which the family is suffering due to the sudden death of the bread earner of the family. Your Lordship, in 2004, the petitioner's wife expired. Your Lordship, before that, she have never given any family declaration that she has remarried, and she was withdrawing the family pension as well as enjoying the compassionate appointment. Your Lordship, only after 2 years, the petitioner have wrote a letter that they need the service benefit of his deceased wife. It was replied by the railway authority that there is no record that you are the husband of the deceased wife. However, thereafter, after 2006, they have submitted the succession certificate, and on the basis of the succession certificate, the other benefit we have released. In 2010, we have released all other benefits, Your Lordship. Your Lordship, they have never moved any application for appointing him on compassionate ground. Your Lordship, in our reply only, we said that in order to avail the service benefit and the compassionate appointment, your marriage declaration was never given by your deceased wife during her lifetime. So even your genuineness as a husband is also doubtful. You clear it. Your Lordship, we have thereafter we have never received any application for appointing him on compassionate ground. Only in the year 2009, that is after 5 years. After 5 years, we have although we are not admitting, because we do not have any record that they have moved any application in 2009 also. But we are assuming that if they moved the application in 2009, that is after 5 years. And the rule is very much clear that after 5 years, if you want to move any applications, then directly you have to move an application before the general manager, and you have to pay for condonation of delay. And only the general manager have an authority to condone the delay or not. And even the general manager cannot endorse to its lower officials. This is all about the fact of the case, Your Lordship. However, if there is a dispute as regards to the service, now after 17 years, they have approached this honorable court, Your Lordship. So the financial crisis is not there. Because after 17 years, they have opposed this.
The application, your application is there in the writ petition.
Yes, yes, your lordship, it's in page 10. Page 10. Annexure A. And lordship, what to say?
10/9/2009.
Yes, your lordship, and the top bottom, the signature seal of the Lumbling division, and it was forwarded to the TRM, is there. Now at this point, if they say that they haven't even received that part. And in their entire affidavit in opposition, if we see that they've regularly said that I had the opportunity, I had the redressal, I could have approached, but I have not appealed my opportunity. And the another thing, your lordship, what learned friend was suggesting, that as regards to this compassionate ground appointment, this railways defense, this cannot be viewed in a similar yardstick, lordship, because this is some of this central agency, there is some statutory provisions for this. And here in the one which I forwarded before your lordship, this clearly says that till 20 years, this DRMs has the power to consider the case.
But there is a rider also here.
Yes,
It says, while considering belated request
yes,
after 5 years, etc., after 5 years, it should,
Yes.
however, be kept in view that the concept of CGA is largely related to the need for immediate assistance to the family of the railway servant in order to relieve it from economic distress. The very fact that the family has been able to manage all these years should normally be taken as adequate proof that the family had some dependable means of subsistence. So such examination should call for a great deal of circumspection as per extant norms.
yes, your
That,
lordship.
that issue is also there.
Yes, your lordship.
Mm. This, the competent authorities, DRM, CWM, HOD. What is CWM? Okay. Then? Anything else?
And as regards to the submission, your lordship, that
What about the submission regarding CAT, alternative remedy?
alternative remedy, your lordship, this honorable court, I would like to.
My lord, Union of India, if it is related to the defense, then Armed Force Tribunal, and Union of India, the other department, the Administrative Tribunal Act. And that also, your lordship, before approaching the head, they have to exhaust all the remedies available in the department.
Lordship, I'm referring to this judgment, 2008, volume 5, SCC 632, at para 3. Para 3, may I humbly read? By now, it is a well-settled principle of law that availability of alternate remedy is not an absolute bar for granting relief in exercise of power under Article 226 of the Constitution. And at para 5, your lordship, it's more clear. We are clearly of the view that as the respondent, Union of India has clearly admitted the liability, the High Court ought not to have delegated the appellant to its alternative remedy and should not have dismissed the writ petition on that count. There is no disputed question of fact in this case. As already noted in the present case, the respondent admitted its liability, and therefore the question raised before the High Court being an admitted fact, the High Court ought not to have directed the appellant to resort to its alternative remedy under the Act. More so, Lordship, here I am before this, your Lordship, for compassionate ground appointment. And therefore, I humbly pray to consider this case, your Lordship. And why I say, your lordship, that there is no dispute as such, because this was disputed earlier back then in 2007. But once pension payment was released in my favor in 2010, your lordship, the dispute goes off.
But the delay part is also there, delay.
Yes, lordship,
It's there.
yes, I was regularly approaching them, and I was assured that I'll get. Of late, I was told that office officer लोग का है, यहाँ तुम्हारा कोई काम नहीं है, पर्ची पहुंच जाएगा. मैंने I was assured that the letter will come to me. The letter will come to me. Regularly, I was assured, and I was forwarding letters for representation to them. But at last, one of the officers, known officers, because of my continuous visit, because it's 2 hours from Dimapur, one of my known officers who told that कोर्ट का कागज लाइए तभी हो जाएगा. That was the last thing that when I took the call.
It's a verbal, oral thing. There is no. Your lordship, with your permission, one more thing I would like to clear, your lordship. The Administrative Tribunal Act, whom to apply, which are the institute is applied under Administrative Tribunal Act, Section 2. Act not to apply to certain person. The provision of this act shall not apply to, number A, any member of the naval, military, or air forces, or any other armed forces of the Union. Number C, any officer or servant of the Supreme Court or of any high court or court subordinate thereto. Number D, any person appointed to the secretarial staff of either House of Parliament or to the secretarial staff of any state legislature or a house thereof, or in case of Union Territory having a legislature of that legislature. So this act is not applicable to, these are the exemption. So the officer of the Supreme Court, High Courts, the Union Territory, state legislature and legislature, and the armed force. Apart from that, any dispute related to the service should be adjudicated by the gate, and the High Court, the divisional bench is the appellate authority, your lordship. In the the cases which I have referred, the L. Chandra case, this is the 7 judges Supreme Court bench cases, which is clearly said that a litigant cannot directly approach the High Court. But they can approach the Supreme Court, your lordship. And the divisional bench of the High Court is the appellate authority of the tribunal, your lordship.
But as stated in that previous judgment, which was cited, there is no absolute bar also, because many times, even in spite of alternative remedy, this court has entertained with petitions. Depends on the facts.
Yes, your lordship. Your lordship, they have never exhausted all the remedies available in the department also, your lordship. Simply writing one letter, only writing the release my pension and other service benefit. They have not mentioned even a word of compassionate appointment. Other service.
The compassionate appointment.
That is given by, that reply was given by me.
Your lordship, that is sufficient enough.
Annexure A.
Yeah, and
Annexure A,
that is given in 2009.
Yes,
That is
this
after
one.
5 years.
That also well within the period of what,
Your
what
Honor,
they
they
have framed.
should know that if there is a delay, they should approach the competent authority. And as I said, your lordship, the law is also clear that compassionate appointment is not a matter of right. Now, to overcome the financial crisis
That
which the dependent of the deceased family member is facing, now it is 20 years, 21 years now, your lordship, 21 years. They approach the court after 17 years.
21.
And the competent authority, what learned friend is suggesting, your lordship, that competent authority is the divisional railway manager. And the divisional railway manager, as per the guidelines, has the power to appoint within 5 to 20 years. That is very much clear, Your Lordship.
Your Lordship, competent authority is general manager, not DRM.
No, as per this.
As per the 2023 circular.
2023 circular, it is the DRM.
Yes.
DRM slash CWM slash HOD.
HODs.
Yes, your Lordship, that master circular number 16, now, which deals with the scheme. That is annexure B of my reply at page number 11. Annexure B of my reply at page number 11.
Hmm.
Appointment on compassionate ground, master circular. Your Lordship, kindly
Yes.
turn page number 14. The conditions are enumerated there. Page number 14, clause 5.
The time limit.
Yes, your Lordship. Normally, all appointment on compassionate grounds should be made within a period of 5 years from the date of occurrence of the event, entitling the eligible person to be appointed on this ground. This period of 5 years may be relaxed by the general manager, subject to the following condition. The power shall be exercised personally by the general manager. It shall not be delegated to the lower authority. The case should not be more than 10 years old as the recount from the date of death. The widow of the deceased employee should not have remarried. The benefit of compassionate appointment should not have been given at any time to any other member of the family or to a near relative of the deceased employee. The circumstances of the case should be such as to warrant of relaxation of time limit for 5 years. The reason for relaxing the time limit should be placed on record.
That's why
Yes.
this circular is of 18/4/85 and 18/4/90.
Yes,
So that has been revised again in
Yes.
this, in 2023.
Lordship, in between, the one which I have filed, that goes back to 1995. The one which I have filed at page 63, but the latest is 2023. And Your Lordship, may I humbly take Your Lordship to my affidavit in reply once, Your Lordship?
Because this master circular, which you are
Yeah.
relying on, this is it appears to be a compilation of many circulars.
Yes, yes.
Yes. So even this time limit part, this is also a circular.
Yes,
This
sir.
is also reproduced from a circular of 1985 and 1990. So another circular which has been issued with regard to the time limit, the latest, this is of 1/2/2023. So there it says for beyond 5 years and up to 20 years, the authority is the DRM slash CWM slash HOD.
Okay, Lordship. But the authority is there to relax.
Yes,
If
yes.
it- yes, Lordship. Your Lordship.
So the cases which are not received within that 5 years,
Yes, Your Lordship.
these
Yes.
will be considered as per the following schedule
Yes.
by the authorities such and such.
Yes.
So accordingly, that 5 years beyond 20 and 25, beyond 25, the authority is given. So for 5 years and up to 20, it's DRM, CWM and HOD. Yes, Mr. Chanda, what were you saying?
Lordship, my affidavit in reply, page 10, annexure 2.
Page 10.
Yes.
Hmm.
That I've already submitted, the last para, Your Lordship. Because why this application, in fact, this letter is not there in my writ petition. The fact that I was not having access to these letters.
Hmm.
And after filing of the writ, I again visited Lumding Division, and I could have received from some of the officers these letters. And these are the admission. Therefore, there were communications with them. And this is their reply. They have said that I'm not eligible to get the FS and CGA. And even if I have the limitation of beyond the period of 5 years, but what I humbly submit, Your Lordship, that FS dues was clear to me, but that CGA was not considered. That is my humble submission, Your Lordship. And this is the reason I have not annexed that in my main rate petition, Your Lordship. Because once they submitted in their affidavit in opposition that I have FD rights, I was sleeping with my rights. These were the phrases used in the affidavit in opposition. But I have not availed those.
Anything else?
Yes. That's it, Your
Yes,
Lordship.
Your Lordship, the remarriage was not updated to the department. That
No,
we have,
but that issue is already settled now
Yes.
because all the dues, pension and
your
everything.
Lordship, there is two things, the
Yes.
other benefit and the compensate appointment. Compensate appointment, as I said, it is not a matter of right. Now the department will see that whether they are facing a financial problem at present, not after 5 years, Your Lordship.
That you have already submitted.
Yes, Your Lordship.
Also for the petitioner, Mr. T. Chanda. And also YP Gupta for the respondents, no?
Yes,
For
Your
all the
Lordship.
respondents. Order received.
For hearing, item number 18.
Oblige, Your Lordship.
Highly obliged.
May I please, my lady?
You have come on contempt.
Yes, and other several grounds.
Hmm. And respondents were for
For the claimants.
claimants. 1 and 2.
Hmm.
No, 1.
One.
1. Yes.
May I please, my lady?
1, 2. Let's see. Yes. Okay, well, just take a break for 5 minutes.
Okay. My lady, this is an appeal against the impugned judgment and order dated 31/5/2022, passed by the learned member MACT Mokshung. On the ground that the injured claimant respondent has sustained injuries on his person and has become disabled, as a result of which on the account of that injuries he has become disabled. And the learned member, while computing the compensation, has committed grave illegality by overlooking the fact that the claim case, which was filed before the tribunal, it was based only on the GD entry. And there are curtain of judgments of the Honorable Apex Court, where the Apex Court has said that GD entry is nothing but it is only for the academic purpose and there has to be an FIR. Number two, my lady, the disability certificate produced by the claimant respondent, there is no whisper in the disability certificate as to the disability is temporary or permanent, and on which part of the body, which part of his body has become disabled. Number three, the doctor who has issued the certificate, it is there are curtain of judgments by the Honorable Apex Court as well as this High Court also, that the disability certificate, if produced by the claimant or the disabled person, has to have produced from the medical board, out of which there should be one competent doctor from the same group.
From that board.
Yes, from that medical board, a doctor has to be from that competent group of medical authority. I mean, if it is of neurology, then one neurosurgeon has to be there. So no doctor was examined. So, this is the fact of the case. And now, my lady, without wasting the time, I would like to take
So
the
that
lady to the
means
ground.
doctor was not examined.
Yes, doctor was not examined. Although disability certificate has been produced, and in the disability certificate, there is no mention of whether the disability is temporary or permanent.
And on which part,
And on which part of the of his person he has rendered the disability. No FIR. Now, I would like to take your lady to my grounds of appeal. Internal page number 5 of my appeal memo.
Yes.
Now, the instant claim case was filed by the claimant under section 166 of the MV Act. And my lady will appreciate the fact that section 166 of the MV Act speaks that whoever it is, the 166 has to be proved. I mean, the ration negligence has to be, yes, ration negligence has to be proved. My lady is aware of the fact. But in the present case, the ration negligence was not proved. the onus lies with the claimant to prove beyond any doubt to prove that rational negligence was of the driver. Now, my third ground is the claim case was filed based on a GD entry without any FIR. So as there is an accident case, there has to be a proper investigation by the police personnel, and without FIR, they cannot move on the basis of a GD entry. So these facts has been overlooked by the honorable tribunal and has rendered the judgment. Then my next ground is the claimant respondent has sustained injury on his left leg. In the claim petition, my lady, in the claim petition, it is averred by the claimant that he has sustained injury on his left leg, whereby there was a fracture on the said leg. But in the disability certificate as well as in the discharge certificate of the hospital where he was treated, there is no mention that as to on which leg he has sustained the injuries and on which part of his body he has suffered a disablement, and whether the disablement is temporary or permanent. And my lady is also aware of the fact that as section 142 of MV Act, it speaks about the permanent disablement. Now, just for academic purpose, if I may read section 142.
Who's that? MZN. Section 142.
Section 142, my lady. May I read?
Which one mentioned? Yes, permanent disablement.
Yes. Now, the permanent disablement, it reads as follows. For the purpose of this chapter, permanent disablement of a person shall be deemed to have resulted from an accident of the nature referred to in subsection 1 of section 140, if such person has suffered by reason of the accident any injury or injuries involving A, permanent privatation of the sight of either eye or the hearing of either ear or privatation of any member or joint, or number B, destruction or permanent impairing of the powers of any member or joint, or number C, permanent disfiguration of the head or face. So as per section 142, permanent disablement is described as follows. Either there has to be a privitation of the sight of either eye or the hearing or any part of the body, then destruction of the powers of any member of the body or joint, or permanent disfiguration of the head or face, my lady. Now, if
But this is no more there, isn't it, in the new amended act?
Yes. The case was of 2020.
This is of 2020.
Yes. So now if we look into the disability certificate. Sorry, I would like to take my lady before disability certificate to the deposition of the claimant respondent, that is PW1.
Position and affidavit of
Uh,
PW1
Yes,
claimant.
claimant.
Yes. Yes.
Yes. Married.
That's right.
From the second paragraph I'm reading. Whereas I am the injured claimant of vehicular accident dated so and so, and I have filed the case against the opposite parties for payment of compensation on account of serious injuries sustained in the accident. It was on so and so when I was standing on roadside at Old Diku, Chimlang village, Mokchung. A Maruti hit me by its front tire. As a result, I sustained serious injury. I was immediately shifted to hospital with the help of villagers and admitted to Dr. So-and-so Hospital, Mokchung, Nagaland, thereafter on so-and-so. After inserting steel plates in fracture part of leg slash tibia, through operation, I was discharged from hospital with an advice for follow-up treatment from time to time. During the course of treatment, I have incurred 2 lakhs as medical expenditure, inclusive of medicines, cost, nursing and nourishment, nursing home charges, so and so, so and so. Apart from this, I have also spent another 80,000 for food and lodging, conveyance of 2 attendants, also for taxi fare and shifting me from one place to another. Till filing of this claim, I have incurred 2,80,000 for my treatment. I am everyday spending money for treatment as still I am under treatment. Prior to accident, I was working as a head mason with daily wage of 800. Now, my lady, if I may describe this as a head mason, these are occasional jobs. These are not day-to-day jobs are readily available. He is a head mason, he will get the job, he will work. Till day I am unable to move my body and there is no hope completely to resume my work. I have old aged father and mother who completely depend on my earning. However, after accident, we are fully under the charity of well wishers. Accident date so and so was the sole negligence of the offending driver who could not control the vehicle due to reckless driving. My total claim in the petition is so and so against different heads and respectfully prayed before this learned tribunal to kindly award in my favor. Now, these are the documents he has exhibited. He has exhibited exhibit P1, P2 is the accident information report under GD number, my lady. There is no FIR dated so and so. Exhibit P3 is the driving license of the driver. Exhibit P4 is the RC of the offending vehicle. Exhibit P5 is the insurance policy. P6 is the birth certificate. P7 is the discharge certificate. P8 are the bulk of cash memos and vouchers. Exhibit P9 is the additional document clinical investigation report. Now, in his deposition, he has stated that there was fracture part on leg of or fracture part of leg slash tibia. Now, my lady, I would like to take you to the cross-examination of the claimant respondent.
On 24th September 2020.
24th September 2020. Yes. My name is Longdisha Sangtam. Father's name is so-and-so. Yes. The date may be recorded, my lady. 24th September 2020. It is correct to say that I am the injured claimant which took accident
Near
Old Diku, Mokchong, Nagaland. Okay. However, a Maruti car bearing number so-and-so in excessive speed driven by Shri so-and-so, he hit me by its front tire. As a result, I sustained serious leg injury and admitted in so-and-so hospital for nearly 30 days. It is also correct to say that I was working as a head mason with daily earning of rupees 800 and age is 32 years. I am completely unable to do any work because of my permanent disablement. Now, the cross-examination was conducted on 24th day of September 2020. Without the doctor's certificate or without the doctor's disability certificate, how he can come to a conclusion that he is of permanent disablement? Number one. Number two, my lady, now the disability certificate. I'm referring to the disability certificate, my lady. It was issued by Government of Nagaland, Department of Health and Family Welfare. Yes. Now, my lady, if
Medical board, IMDH, Mokutung, this one.
this one, my lady,
Yes.
inclusion
Yes.
of the photograph of the claimant itself.
Yes.
Now,
Exhibit
if-
10.
Yeah,
Exhibit 10.
yeah. It's, may I just refer the date of the certificate, my lady? It is of 12/10/2021. The certificate, disability certificate was issued in the year 2021, whereas the cross-examination of the claimant respondent was conducted on 24th September 2020. And in the disability certificate, there is no mention whether the disability is permanent or temporary. It is just assumed to be 20% disablement.
24/9/2020. The certificate is 12/10/21.
Yeah, certificate dated is 12/10/2021.
%20.
Just below the date, it is written as, this is certified that Sri so-and-so, son of so-and-so, date of birth so-and-so, resident of so-and-so village is suffering from dash permanent/temporary disability of the following categories. There is no mention. And in the bottom part, it is post-operative case of compound fracture tibia, 20% disablement. Now, annexure K to claimant's claim petition is the discharge certificate, which he has enclosed with the claim petition. The discharge summary of the same hospital which is issued, where he was treated, Dr. Imkong Liba Memorial District Hospital, Mokchung.
Discharge certificate.
Yes. It also speaks nothing about the disablement.
Yes.
Now, the PW2 is an officer from traffic control, Mokchung. There was no specific IO appointed to investigate the matter. This is the statement. It is right after PW1 and the second page of PW1, my lady. Mr. Weimerin.
Yes. What is he? Serving in traffic control.
Yes. My name is Weimerin and serving in traffic control, Mokchung. He may be some officer of the traffic control, Mokchung. So there is my main point to bring it before my lady is that there is no specific IO was appointed by the concerned police as because there is no FIR registered. Even in his deposition, he has stated that on receiving the information of this accident, they have visited the place of occurrence and found a Maruti car parking on the roadside along with the driver, Sri so and so. On further inquiry, it was ascertained that a Maruti car bearing number so and so has hit one person, namely Longdishe Sanktam, by its front tire, which was standing on the roadside. Victim got severe injury and immediately shifted to the hospital for medical treatment. Accident occurred on 21/9/2020. Is the sole ration negligent of the offending Maruti car. Without any investigation, how can he come to a conclusion that the negligence was on the part of the driver of the vehicle? There was no investigation conducted. And annexure F is a letter
Annexure.
F of the claim petition by the traffic control room. Officer in charge of traffic control, Mokchung. it speaks that both the parties have proposed for an amicable settlement since the incident was not intentional.
Actually, there are no annexures in the claim petition. Was it exhibited? That letter,
Sorry, my lady.
was that letter exhibited during the trial? Because
I'll just.
accident information report is exhibit P2. RC is exhibit 4. Insurance policy is exhibit 5. Driving license, exhibit 3. Discharge certificate, exhibit 7.
On the last part of the exhibit, it speaks that exhibit P9 is the additional documents and clinical investigation report. But if it is not exhibited, this was just made a part of the annexure of the claim petition.
That is in the form of a letter or what is it?
Yes, that is in the form of a letter.
That is not there in the reports.
Okay. If I may,
Can you see? Please supply a photocopy later because this is not here,
Okay.
the report.
now my lady, if I may take my lady to the grounds,
Then-
back to the grounds. Back to the grounds, ground number. Ground number 4. Has my lady got it?
Yes.
Yes. For that, the London member failed to appreciate the fact that the injury sustained by the claimant respondent was simple injury and not permanent disability. It is simple injury because it was not mentioned in the discharge certificate as well as in the disability certificate as to whether it is temporary or permanent. So in absence of that, it has to be assumed that the injury sustained by the respondent claimant is of simple in nature. More so, the disability of the claimant is a temporary or permanent one is not specified in a disability certificate. In absence of such clear distinction of the temporary or permanent disability of the claimant, the learned tribunal ought not to have come to a conclusion that the claimant sustained permanent disability and to make the appellant insurance company liable to pay the compensation. As such, the award passed by the learned tribunal is perverse and liable to be set aside. Now, my lady, on the 7th page of the impugned judgment, 7th page, it is dealt in issue number 3. 7th page of the judgment.
Issue number
3.
3.
Whether the claimant suffered permanent disability, if so, to what extent?
Yes,
Yes.
please read.
Yes. In the examination in chief, PW1 stated that hit me by its front tire. As a result, I sustained serious injury and I was immediately shifted to the hospital with the help villagers and admitted in Dr. So-and-so hospital, Mokchung, Nagaland. Thereafter, on 24/2/20, after inserting steel plate in fractured part of leg tibia through operation, I was discharged from the hospital with an advice for follow-up treatment from time to time. Till date, I am unable to move my body and there is no hope completely to resume my work. The claimant in support of the injury marked and exhibited medical documents as Exhibit P7, discharge certificate of Dr. So-and-so Hospital, Mokchung, Exhibit P8, bulk cash memos and vouchers, Exhibit 10, disability certificate, and Exhibit P9, additional documents and clinical investigation reports. Learned counsel for the insurer submitted that though the claimant has produced disability certificate issued by the Medical Board of Civil Hospital, Mokchung, no doctor was examined to prove its authenticity. As such, it is doubtful and liable to be rejected. My lady may be appreciated that here also the learned counsel at the trial stage, even in the WS, it was taken as a stand that doctor has to be examined. Even in the judgment, it is pronounced that the stand was taken by the learned counsel at the time of argument. As such, it is doubtful and liable to be rejected. I do not find force on the objection raised by the counsel for the insurer. It has been held in Katenoff cases that proceedings under MV Act are not akin to proceedings as in civil and criminal cases, and hence strict rule of evidence are not required to be followed in this regard. The parties are to prove his case on preponderance of probability and not on beyond reasonable doubt, like criminal case. Claimant has proved his case by adducing evidence by way of disability certificate certifying 20% disability. Therefore, I am inclined to hold that the claimant has suffered 20% permanent disability. Here also, the learned tribunal has taken on its own whims that the claimant has suffered 20% permanent disability, although there is no whisper in the disability certificate that the claimant has suffered either temporary or permanent disablement. More so in which part of the body? Now, with regard to this disability, I'd like to take my lady with the judgment of the Honorable Apex Court.
Para 6 to 20.
Paragraph number 6.
Yes.
Disability refers to any restriction or lack of ability to perform an activity in the manner considered normal for a human being. Permanent disability refers to the residuary incapacity or loss of use of some part of the body found existing at the end of the period of treatment and recuperation after achieving the maximum bodily improvement or recovery which is likely to remain for the remainder life of the injured. Temporary disability refers to the incapacity or loss of use of some part of the body on account of the injury, which will cease to exist at the end of the period of treatment and recuperation. Permanent disability can either be partial or total. It is also referred by the Honorable Apex Court here. Permanent disability can either be partial or total. Partial permanent disability refers to a person's inability to perform all the duties and bodily functions that he could perform before the accident, though he is able to perform some of them and is still able to engage in some gainful activity. Total permanent disability refers to a person's inability to perform any avocation or employment related activities as a result of the accident. The permanent disability that may arise from the motor accident injuries are of a much wider range when compared to physical disabilities, which are enumerated in Persons with Disabilities, Equal Opportunities Protection of Rights and Full Participation Act 1995. But in any of the disabilities enumerated in Section 2(1) of the Disabilities Act are the result of injuries sustained in a motor accident, they can be permanent disability for the purpose of claiming compensation. Number 7. The percentage of permanent disability is expressed by the doctors with reference to the whole body or more often than not with reference to a particular limb. When a disability certificate states that the injured has suffered permanent disability to an extent of 45% of the lower limb, it is not the same 45% permanent disability with reference to the whole body, my lady. The extent of disability of a limb or part of the body expressed in terms of a percentage of the total functions of that limb obviously cannot be assumed to be the extent of disability of the whole body. If there is 60% permanent disability of the right hand and 80% permanent disability of the left leg, it does not mean that the extent of permanent disability with reference to the whole body is 140%. That is 80 plus 60. If different parts of the body have suffered different percentages of disabilities, the total sum thereof expressed in terms of the permanent disability with reference to the whole body cannot obviously exceed 100%. Number 8, where the claimant suffers a permanent disability as a result of the injuries, the assessment of compensation under the head of loss of future earnings would depend upon the effect and impact of such permanent disability on his earning capacity. Tribunal should not mechanically apply the percentage of permanent disability as the percentage of economic loss or loss of earning capacity. In most of the cases, the percentage of economic loss, that is percentage of loss of earning capacity arising from a permanent disability, will be different from the percentage of permanent disability. Some tribunals wrongly assume that in all cases, a particular percentage of permanent disability would result in a corresponding loss of earning capacity. And consequently, if the evidence produced show 45% as the permanent disability will hold that there is 45% loss of future earning capacity. In most of the cases, equating the extent of loss of earning capacity to the extent of permanent disability will result in award of either too low or too high a compensation. What requires to be assessed by the tribunal is the effect of the permanent disability on the earning capacity of the injured. And after assessing the loss of earning capacity in terms of a percentage of the income, it has to be quantified in terms of money to arrive at the future loss of earnings by applying the standard multiplier method used to determine loss of dependency. We may, however, note that in some cases on appreciation of evidence and assessment, the tribunal may find that percentage of loss of earning capacity as a result of the permanent disability is approximately the same as the percentage of permanent disability, in which case, of course, the tribunal will adopt the said percentage for determination of compensation. Therefore, the tribunal has to first decide whether there is any permanent disability, and if so, the extent of such permanent disability. This means that the tribunal should consider and decide with reference to the evidence whether the disablement is permanent or temporary, my lady. And in the disability certificate, there is no whisper whether it is temporary or permanent. Number 2, if the disablement is permanent, whether it is permanent total disablement or permanent partial disablement. Number 3, if the disablement percentage is expressed with reference to any specific limb, then the effect of such disablement of the limb on functioning of the entire body, that is the permanent disability suffered by the person. If the tribunal concludes that there is no permanent disability, then there is no question of proceeding further and determining the loss of future earning capacity. But if the tribunal concludes that there is permanent disability, then it will proceed to ascertain its extent. After the tribunal ascertains the actual extent of permanent disability of the claimant based on the medical evidence, it has to determine whether such permanent disability has affected or will affect his earning capacity. Now, if I may read the whole, because it has a direct
Which one?
uh,
Para 10.
para 10 is similar to 8 and 9, my lady.
Para 13.
Para 11. The tribunal should not be a silent spectator when medical evidence is tendered in regard to the injuries and their effect, in particular to the extent of permanent disability. Section 168 and 169 of the Act make it evident that the tribunal does not function as a neutral umpire as in a civil suit, but as an active explorer and seeker of truth who is required to hold an inquiry into the claim for determining the just compensation. The tribunal should therefore take an active role to ascertain the true and correct position so that it can assess the just compensation. While dealing with personal injury cases, the tribunal should preferably equip itself with a medical dictionary and a handbook of evaluation of permanent physical impairment. For example, the manual for evaluation of permanent physical impairment for orthopedic surgeons prepared by the American Academy of Orthopedic Surgeons or its Indian equivalent or other authorized text. For understanding the medical evidence and assessing the physical and functional disability, tribunal may also keep in view the first schedule of the Workmen Compensation Act 1923, which gives some indication about the extent of permanent disability in different types of injuries. In case of workmen, if doctor giving evidence uses technical medical terms, the tribunal should instruct him to state in addition in simple non-medical terms the nature and the effect of the injury. If a doctor gives evidence about the percentage of permanent disability, tribunal has to seek clarification as to whether such percentage of disability is the functional disability with reference to the whole body or whether it is only with reference to the limb. If the percentage of permanent disability is stated with reference to a limb, the tribunal will have to seek doctor's opinion as to whether it is possible to deduce the corresponding functional permanent disability with reference to the whole body, and if so, the percentage. Now, in this case, my lady will appreciate that there is no doctor examined. Even in the disability certificate, it is not ascertained whether the disability is permanent or temporary or permanent partial, as discussed by the Honorable Apex Court in the case at hand. Now, this is the thing, and I would like to take my lady to another judgment. Please, I'll come to that judgment later on, my lady. Please, now 2001 1 GLT.
Two 2001.
1 GLT. 393.
393.
93.
Read. It's okay.
May I read?
Yes.
Oh, I had given the list of books earlier. Mm. May I read?
Yes.
Yes. It is in respect of examination of a doctor. It says that The whole contention of the appellant is that the learned tribunal arrived at a conclusion that the claimant suffered permanent disability without examining the doctor. Since the claimant sustained injury, it was incumbent on the part of the claimant to examine the doctor and establish its case as to what percentage of permanent disabilities was suffered by the claimant. It would clearly appear that besides submitting a certificate from the doctor, no doctor who has treated the claimant have been examined by the claimant. And in my case, it is same as it is. The doctor who has treated the claimant has not been examined by the claimant. Non-examination of the doctor to establish the extent of disability suffered by the claimant deny the opportunity to the insurance company to cross-examine the doctor. In our jurisprudence, witness put up by either of the parties is subject to cross-examination so as to test the veracity or truthfulness or correctness of the statement of the witness. In the instant case, no doctor has been examined to establish the extent of disability suffered by the claimant. And in that view, the permanent disability has not been proved. Apart from that, the tribunal saddled the liability with the insurance company on compensation assessed on the basis of permanent disability suffered by the claimant, without giving any opportunity of cross-examining the doctor. In the result, the impugned judgment and award dated so-and-so passed by the learned tribunal in MSC case number so-and-so is hereby set aside. The case is remanded back to the tribunal to start the proceeding afresh from the stage of examination of doctor. Another judgment, although it is on the same footing, 2010 1 GLT 571.
2010 1 GLT
571.
57.
Paragraph number 4 and 7. It is on the same footing, non-examination of the doctor. Now, my lady, again, I would like to take my lady to the impugned judgment part. On the computation of compensation. The 8th page of the impugned judgment.
Yes.
Yes. Has my lady got it?
Yes.
Yes. It says that heads in calculation, income 17,500. So he has stated in the claim petition that he earns rupees 800 daily. However, the learned tribunal has taken rupees 700 per day and has calculated it for 25 days in a month, 25 days instead of 30 days. Then has applied the multiplier of 16 as his age was 32 on the date of accident. Then again has added 20% disability, though it was not proved as no doctor was examined. Then special diet and attendant charges, medical expenditure, future treatment, pain and suffering, loss of future prospect. Here, loss of future prospect, as my lady will appreciate the fact that loss of future prospect is awarded in case of death and not in injury cases. And also has directed the appellant insurance company to settle the award awarded by the learned tribunal with a rate of interest 9% from the date of filing the petition. Now, I would like to take my lady to another judgment of our Honorable High Court. paragraph number 19 and 20. my lady. The last page.
Yes.
Yes, it says, the operative part starts from the fourth line of paragraph number 19. Although, it starts with the word although.
The claim petition.
Although the claim petition was filed on 29/5/2006, but the evidence on affidavit was filed only on 9/8/2011. Therefore, the respondent number 2 and respondent number 4 are liable to pay interest from date of filing of evidence on affidavit and not from the date of filing claim petition. Also, the interest awarded in this appeal is 9%. Whereas my lady is aware of the fact that in the case of Sarla Verma, decided by the Honorable Supreme Court, it is directed to be of 6%. Yes. Then on my humble submission, as the disability has not been proved by the claimant, my lady may be pleased to remand the case for examination of the doctor, as well as we may be given opportunity to cross-examine him.
You've given 2 copies of this.
Yes, yes.
C63.
Okay.
Yes.
Please, your lordship. So far as the question raised by the appellant regarding rash and negligent driving, I'll just take your lordship to the award. Paragraph. Page 12 is of the, page 12 of the
Internal
yes,
page.
yes, appeal. Unfortunately, I don't have all the other reports, but from here, things will emerge. I'll just, the examination of the petitioner, the claimant and the police is done. Then I'll take your lordship to page 13, the last paragraph. The counsel for the opposite parties did not rebut the statements, evidence rendered by the BWs. It should be contested in the original court. In the affidavit, in the affidavits, written statements filed by the owner of the vehicle as well as the driver, it should be clearly laid out that it is not a negligent, rash and negligent driving. Once it is admitted, it is an admitted case. And as judgments in various cases in general has been laid down over here by the learned tribunal that evidence when it comes to motor vehicles cases.
This is preponderance. only.
Yes, yes, preponderance. So it is an admitted, they are not denying that no accident happened. They are bringing out some discrepancy in dates.
They are not so much on this, but
Yes,
more about
so-
the disability.
Yes, only on the disability certificate now, your lordship. So the case which he has produced, which he has, the learned counsel for the company has submitted, that Raj Kumar versus Ajay Kumar and another.
in this paragraph 12, if you're, this is of importance, paragraph 12. If I may read.
This Rajkumar case.
Yes, paragraph 12, because this is of importance. The tribunal should also act with caution if it proposed to accept the expert evidence of doctors who did not treat the injured, but who give ready-to-use disability certificates without proper medical assessment. There are several instances of unscrupulous doctors who, without treating the injured, readily giving their liberal disability certificates to help the claimant. But this is important, this sentence, but where the disability certificates are given by duly constituted medical boards. In this case, it is a duly, from the evidence, it was given by a duly constituted medical board. They may be accepted subject to evidence regarding the genuineness of such certificates. So if the certificate is genuine, it has to be accepted.
Subject to evidence.
Subject to evidence, yes. Where the subject to evidence regarding the genuineness of such certificate. Now, if it is produced and the other parties having gone through it and having done their due diligence, if they have not objected to it, now at the appeal stage, raising objections to it, it is not appropriate. Here, the board has given the medical certificates. In the tribunal, no objection was raised. Now it is being questioned at the appellate stage.
No, objection was raised during the trial.
But whether it is genuine or not, that is the question.
No doctor was examined to prove
Yes,
its authenticity. As such, it is doubtful and liable to be rejected. That is what you said.
But it is a proof that, that you only need to prove the genuineness of the medical certificate, not the contents thereof, not what is in the inside the certificate. Only genuineness of the certificate, whether it is genuine or not. That is a different issue. Here, their stand is that the doctor who issued the certificate should be examined to ascertain the extent of disability. But here, as per this judgment, it is very clear, only the genuineness of the certificate needs to be ascertained.
But
So-
you read after that the
Yes,
second line again.
here it is
The-
with regard to the other doctors only, the
The
others.
tribunal
The
may
tribunal,
invariably make it
yes,
a
make it a
point.
point
Yes.
to
require
require the evidence of the doctor who
Treated
treated the injured or who assessed the
assessed
permanent
the
disability.
permanent-
But here in this case, it is the doctor who
So-
issued, in the earlier, there are two issues here. The court has discussed two issues.
Mm.
Where a doctor who has treated or who has issued the certificate is concerned, in this case, it has to be examined. He has to be properly examined. But in the case of a board, duly constituted board, only the genuineness of the certificate needs to be ascertained. That is
Who
the
treated the injured
Yeah.
who has
Yes.
who assessed the
the permanent disability.
So it is the board who has assessed the permanent disability in
Yes.
this case. So
Mere
the
production
mere production of
of
a
a
disability certificate will not
discharge
be proof.
certificate will not be proof of the extent of disability stated therein unless the doctor who treated the claimant or who medically examined and assessed the extent of disability of claimant is tendered for cross-examination with reference to a certificate. If the tribunal is not satisfied with the medical evidence produced by the claimant, it can constitute a medical board from a panel maintained by it in consultation with reputed local hospitals, medical colleges, and refer the claimant to such medical board for assessment of the disability. So here, if the certificate issued by the doctor and after examining the doctor concerned who has issued a certificate, if it is not satisfied, then a board may be set up. But here a board was set up. So the question is only whether genuineness, the board has actually issued the certificate or not, because a board is a board. It is an expert committee. So even if it is to be referred, the tribunal will have to set up a medical board to examine it. So whether the certificate was genuine or not, that is the issue to be considered. Yes, it is not denied that no doctor was examined. But my contention is that here in this case, it was a board which has issued the certificate. The only question that is required to be considered is whether the certificate issued by the board is genuine or not. That is my position. Of course, it will be subject to this honorable court's reasoning and decision. Now, with regard to the interest, your lordship, so far as the assessment of the heads of compensation is concerned, it has to go by settled law, which have clearly been laid down by the Supreme Court in catena of decisions. I'm not going into those areas. But so far as 9% is concerned, the courts have been, various courts have been giving their own, even
Yes,
the
some
Supreme
6,
Court,
some
yes,
9.
some 9, even as recently, this honorable court has in recent decisions also, if I may, there are other cases, but I just present one case and then one Apex Court case. Paragraph 15 of this, page 7 and 8.
Also 9%.
Yes, 9% per annum from the date of filing of the claim petition till its realization. The payment shall be made within 60 days, so and so. Now,
Yeah. But it's nearly, I think you're nearly
yes,
done.
well, it's done.
Yes,
It's
yes.
more or less done. One more judgment regarding the percentage. This is a 2019
1 minute.
case decided on 17/10/2022 by the Supreme Court.
This is also 9%.
And this is also 9%. If your lordship may go to the last paragraph, 26, the last part, 1 page. Paragraph 26, the insurance company is directed to pay the enhanced compensation amount of rupees 29 lakh so and so to the appellants along with the interest at the rate of 9% per annum. So there is no infirmity in the interest required. The only issue now is with regard to the medical board.
Yes, only that.
Yes, I leave it to
Yes.
your lordship.
The difficulty is that
Consideration. Yes,
this
yes.
court has also
Yes.
been a tribunal and
Yes.
faced with similar situation.
Yes.
Okay. Order reserved. Just call it.
My lady, I'd like to point out one small thing
Yes.
as pointed by my learned senior colleague in the judgment that there is no mention by the opposite party's counsel at the time of argument during a trial stage that the certificate produced by the claimant. My lord, that
No, no, regarding the disability
yes,
certificate.
yes. Until and unless the doctor was examined and we ought to have given an opportunity to cross-examine him, how the genuineness of the certificate will come to effect. It is the tribunal who has stated that he has produced the disability certificate, and by that way the tribunal is inclined to take 20% permanent disablement of the claimant. But if my lady may peruse the disability certificate, it is nowhere in the disability certificate mentioned whether that is temporary or permanent. More so, no bodily part has been
mentioned.
mentioned therein. So this is a fit case. My lady may remand the case to the
Will
tribunal
be determined.
for fresh examination of the doctor in the interest of justice.
Learned counsel for the appellant, Mr. V. Devnath, and learned counsel, Dr. Punganer for the claimant respondent. Order is reserved. Print out copy and then this one, this one.